Hello everyone, welcome back again to my channel. Before starting this video, don't forget to like, comment and subscribe. Now let's start this video. Implementation of agreements with foreigners part 6. Indonesian traditional fishing right in waters of Australia. For centuries, Indonesian fishermen from eastern and southern Indonesia have traditionally visited the water of the coast of Australia for various kinds of traditional fisheries. Fishermen from Ambon and the South Moluccas, for instance, have traditionally visited the Gulf of Carpentaria for pearl fisheries. The Australian government has recognized these traditional fishing activities which have continued up to the present without much difficulty. On the other northern coast of Australia, Indonesian fishermen, primarily from the Lesser Sunda Island, have also regularly visited the area around the Ashmore and Cartier Island group for various kinds of fishing. Many of this island group, now part of Australia, were once regarded as belonging to the ancient kingdom of Roti, an island chain in the Lesser Sunda Island group. The fishing activities themselves were not much a problem since the government of Australia has always recognized the traditional fishing right of Indonesian fishermen. The problem was more of an environment nature than of fisheries. The Indonesian fishermen, being traditional, use traditional vessels, equipment, and methods of fishing. They were generally unaware of modern environmental problems. They, therefore, had the habit of going ashore to look for fresh water and firewood. Sometimes they hunt birds which in Australia were sometimes seasonally protected. After various discussions between the government of Australia and the government of Indonesia, a memorandum of understanding was signed on 7 November 1974. The memorandum granted Indonesian traditional fishermen permission to operate in the exclusive fishing zone and the continental shelf adjacent to the Australian mainland and offshore island until 28 February 1975. As of March 1975, Australian laws and regulations would apply within its 12 miles exclusive economic zone. Traditional fishermen means the fishermen who have traditionally taken fish and sedentary organisms in Australian waters by methods which have been traditionally used for decades of times. Exclusive fishing zone means the zone of waters extending 12 miles seaward from the baselines from which the Australian territorial sea is measured. The memorandum further stated that after 28 February 1975, Australia will continue to respect and allow operation by Indonesian nationals around Ashmore Reef, Cartier Islet, Scott Reef, Sering-Patam Reef, and Browse East Islet subject to the following conditions. First, the operation shall be limited to traditional fishermen. Second, landings by Indonesian traditional fishermen for the purpose of obtaining supplies of fresh water shall be continued to East Islet and Middle Islet of Ashmore Reef. Third, traditional Indonesian fishing vessels seeking shelter may do so within the island groups mentioned above, but persons shall not go ashore except the mention in the point 2 above. The memorandum stipulated further that Indonesian fishermen would not be permitted to take on turtles in the Australian 12 miles exclusive economic zones. Troches, pitch de mer, abalone, green snail, sponge, and all mollusks can be taken from seabed adjacent to Ashmore and Cartier Island, Browse Islet, and Scott and Sering-Patam Reefs. Implementing the memorandum has not been easy, Up to this day, despite numerous circulars issued by either the Directorate General for Fisheries or the local government, fisheries have continued to violate the memorandum. It has not been easy also to ask the traditional fishermen to refrain from going on shore of an island where they have traditionally visited for age. The problem was therefore more one of education rather than one of law enforcement. It is fortunate that up to the present, the Australian government has shown sufficient understanding of the complexities of an enforcement action. Recently, Australia has also declared its intention to enforce a 200 miles economic zone around its territory. The 200 miles area, if claimed by Australia, although it has not been clearly delimited, would almost certainly affect the fishermen from neighboring countries, especially fishermen from Indonesia who have been fishing in the area. This is something different from the traditional fishermen discussed above. Taking cognizance of this act, Australia has also indicated its willingness to consider the matter and has offered the state concerned, including Indonesia, opportunities to discuss whatever fishing interest in Indonesia has in the area which would be claimed as part of Australian exclusive economic zone. The matter is now under serious study by the states concerned. The conclusion, at present, the only important agreement of fisheries concluded by Indonesia is the interim arrangement of 1968 with Japanese Fishing and Tuna Association to fish in the Banda Sea area. After several renewals, the interim arrangement was replaced in 1975 by a profit-sharing arrangement between the Indonesian State Fisheries Enterprise and the Japanese Fishing and Tuna Associations. The terms of the interim as well as the profit-sharing arrangement were not really profitable to Indonesia. It felt that the terms set forth in the interim arrangement and the profit-sharing system needed revision. The arrangement concluded in the past have had many political overtones. Enforcement of this arrangement has not been easy. Firstly, some of the fishing vessels themselves were reluctant to report to the Indonesian Naval Authority at Ambon after completing their fishing activities. Secondly, the area of fishing was too large for the limited number of Indonesian patrol facilities to effectively supervise, resulting in many violations committed unnoticed. Thirdly, the Indonesian law enforcement capabilities themselves were extremely limited either in number, equipment, or other facilities. The emphasis on economics in the Indonesian development program within the last 5 years development plans has failed to strengthen or improve Indonesian surveillance capabilities for law enforcement at sea. Fourthly, while there was inadequacy in the capability and the efficiency of the law enforcement agencies at sea, the procedures involving judicial solution for any violators also required improvement, particularly in speed. Finally, coordination among the various law enforcement agencies at sea was poor. It is a well-known fact that in Indonesia the Navy, Police, Immigration, Customs, and Communication Office has its own enforcement jurisdiction and officer at sea. Although in theory these agencies are under the operational command or regional defense commanders, in practice it has not been easy for them to coordinate their activities at sea. The other arrangement that Indonesia will make with regard to fishing activities in its archipelagic waters concern the implementation of the traditional fishing rights of the immediately adjacent neighboring states in certain areas of the archipelagic waters. The details of these arrangements must be negotiated and determined further through bilateral arrangement. Indonesia also has problems concerning its traditional fishing rights in water off the coast of some of its neighbors. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.